A company has collapsed. Creditors have lost crores. Employees are waiting for dues. Investors are staring at massive losses. The liquidator begins examining company records and discovers something shocking. Company funds were diverted. Assets were transferred without justification. Related party transactions enriched insiders. Directors approved questionable decisions. Key officers failed to perform their duties. Valuable corporate resources disappeared while stakeholders suffered. Now comes the most important question of all. Can the law force these individuals to compensate the company? Can directors be ordered to personally restore losses? Can management be held financially accountable for misconduct committed years earlier? The answer lies in one of the strongest accountability provisions under the Companies Act 2013, Section 335, which empowers the tribunal to assess damages against delinquent promoters, directors, officers, managers, liquidators, and other persons responsible for corporate misconduct. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today, we are discussing Section 335 of the Companies Act 2013, a provision that stands at the heart of corporate accountability during winding up. This section is extremely important because it transforms corporate governance principles into practical remedies. Many provisions establish duties. Many provisions prescribe obligations. However, Section 335 focuses on consequences. It answers a crucial question. What happens when individuals entrusted with corporate power abuse that trust? The legislative answer is clear. They may be required to compensate the company and restore losses suffered by stakeholders. To appreciate the significance of this provision, we must first understand a basic principle of corporate governance. A company acts through human beings. Directors make decisions. Managers supervise operations. Officers implement policies. Promoters often influence strategic direction. Liquidators administer assets during winding up. Each of these persons occupies a position of responsibility. The law expects them to act honestly, diligently, and in the interests of the company. When those expectations are violated, accountability follows. Section 335 provides the mechanism through which that accountability may be enforced. The legislative intent behind the provision is protection of stakeholders. Creditors should not suffer because management misused corporate resources. Employees should not bear losses caused by misconduct. Investors should not be left without remedies when governance failures occur. The tribunal therefore receives authority to investigate conduct and assess damages where appropriate. This reflects a broader governance philosophy. Power without accountability undermines confidence in the corporate system. The section applies to a wide range of persons. Promoters may fall within its scope. Directors may fall within its scope. Managers may fall within its scope. Company officers may fall within its scope. Liquidators themselves may fall within its scope. The legislature intentionally adopted broad language because corporate misconduct can arise at multiple levels of management. The law therefore focuses on conduct rather than job title. One of the most important concepts associated with Section 335 is misfeasance. Misfeasance refers to improper performance of duties resulting in loss or damage. A person may possess lawful authority. However, if that authority is exercised improperly, liability may arise. This distinction is extremely important. Not every mistake constitutes misfeasance. Not every unsuccessful business decision results in liability. The law recognizes that genuine commercial judgment may sometimes prove incorrect. Corporate law does not punish honest business failure. Section 335 targets misconduct rather than bad luck. This is a favorite examination concept. Students often assume that losses automatically create liability. That assumption is incorrect. The key issue is whether losses resulted from breach of duty, misconduct, misuse of authority, or other improper conduct. The law, therefore, distinguishes between commercial risk and governance failure. Another important expression connected with Section 335 is breach of trust. Directors and officers occupy positions of trust. They control assets that belong to the company. They manage resources on behalf of stakeholders. They possess access to information unavailable to others. These responsibilities create fiduciary obligations. When those obligations are violated, consequences may follow. Section 335 reinforces this principle. The provision also addresses situations involving misapplication of company money or property. Corporate assets belong to the company. They do not belong to individual directors. They do not belong to promoters. They do not belong to managers. The law, therefore, treats unauthorized use of company property seriously. A practical example can help illustrate the provision. Suppose a director causes the company to transfer valuable assets to a related entity at a significantly undervalued price. The transaction benefits insiders but harms the company. Years later, the company enters liquidation. The liquidator investigates the transaction. Section 335 may provide a basis for seeking compensation. Consider another example. A manager authorizes payments lacking commercial justification. Records are inadequate. The company receives no identifiable benefit. Losses result. The company eventually enters winding up. Again, the conduct may attract scrutiny under Section 335. These examples demonstrate how the provision protects corporate resources. Another important feature of the section is the role of the tribunal. The tribunal acts as the adjudicating authority. It reviews evidence, it examines records, it hears arguments, it evaluates conduct. If misconduct is established, appropriate orders may be passed. These orders may require repayment, they may require restoration of property, they may require financial contribution, they may require compensation for losses. The objective is to restore value to the company and protect stakeholder interests. The governance philosophy behind the provision is particularly powerful. The law does not merely seek to punish wrongdoing. The law seeks to repair damage. Recovery of value is often more important than punishment. Creditors benefit when losses are recovered. Investors benefit when assets are restored. Employees benefit when additional resources become available for distribution. For company secretaries, Section 335 highlights the importance of governance controls. Board approvals should be properly documented. Related party transactions should be scrutinized. Conflicts of interest should be disclosed. Statutory records should be maintained carefully. Strong governance processes reduce exposure to future disputes. For chartered accountants, financial records frequently become central evidence. Ledger entries, bank statements, audit observations, supporting documentation, all may be critical when assessing liability. For cost accountants, operational records often reveal whether transactions possessed genuine commercial justification. For advocates, proceedings under Section 335 frequently involve detailed factual and legal analysis. Questions of duty. questions of authority, questions of disclosure, questions of causation, questions of loss, all may become relevant. One hidden examination concept involves causation. It is not enough to establish that misconduct occurred. There must often be a connection between the conduct and the loss suffered. Understanding this relationship is essential. Another practical lesson concerns documentation. Directors frequently underestimate the importance of records. Years after a decision is made, board minutes, valuation reports, legal opinions, and financial analysis may become critical evidence. Good documentation protects both the company and its management. A useful case study style illustration can further explain the section. Imagine a company entering liquidation with liabilities exceeding assets by 300 crore rupees. The liquidator discovers that substantial sums were transferred to related entities over several years. Commercial justification appears weak. Approvals are unclear. Documentation is incomplete. Stakeholders seek accountability. Section 335 provides a mechanism through which the tribunal may assess conduct and determine whether compensation should be ordered. The provision therefore serves as both a recovery tool and a governance safeguard. Another important governance lesson is that transparency remains the best defense. Transactions undertaken honestly, approved properly, disclosed adequately, and supported by commercial rationale are generally easier to defend. Governance failures often arise when transparency is absent. The section also strengthens investor confidence. Investors are more willing to commit capital when they know that remedies exist against persons who misuse corporate resources. Strong accountability provisions support healthy capital markets. Another hidden practical insight is that liquidation often reveals issues that remained unnoticed during normal operations. Transactions that attracted little attention years earlier may receive intense scrutiny during winding up. This is why compliance should never be viewed as a mere formality. The provision also connects with other important sections dealing with fraudulent conduct, wrongful trading, recovery of property, director accountability, fiduciary duties, and stakeholder protection. Together, these provisions create a comprehensive framework for corporate responsibility. From a secretarial audit perspective, recurring governance failures, weak internal controls, undocumented transactions, and conflict of interest concerns should always receive careful attention. These issues often become highly significant during liquidation proceedings. Although Section 335 does not prescribe routine ROC filings, shareholder approvals, explanatory statements, special resolutions, or ordinary resolutions, its practical impact can be enormous. Crores of rupees may be involved. Personal liability may arise. Corporate reputations may be affected. Stakeholder recoveries may increase substantially. The consequences are therefore significant. For company secretaries, the section reinforces governance discipline. For chartered accountants, it emphasizes financial integrity. For cost accountants, it highlights operational accountability. For advocates, it provides an important recovery mechanism. For directors and officers, it serves as a reminder that corporate authority carries legal responsibility. As we approach the conclusion, it becomes clear that Section 335 is fundamentally about accountability and restoration. Corporate law recognizes that businesses face risks and uncertainties. What it does not tolerate is misuse of corporate power at the expense of stakeholders. The law therefore provides mechanisms to recover losses and restore value where misconduct has occurred. In conclusion, Section 335 of the Companies Act 2013 represents one of the strongest accountability provisions in the winding up framework. By empowering the tribunal to assess damages against delinquent promoters, directors, managers, officers, liquidators, and other responsible persons, the section protects creditors, investors, employees, and the integrity of the corporate system. For company secretaries, chartered accountants, cost accountants, advocates, insolvency professionals, directors, investors, and governance practitioners, understanding Section 335 is essential because it demonstrates a core principle of corporate law. Those entrusted with corporate power must remain accountable for the consequences of misconduct. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India, ICSI. However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India, ICSI, and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information, UPSI, confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SAYBEE, Prohibition of Insider Trading, Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.